Good evening. Tonight we begin with a developing story that's sending shockwaves across the globe. What started as a routine political exchange has suddenly escalated into a high-stakes situation with serious consequences for millions. Sources say the decisions made in the last 24 hours could reshape economic stability, international relations, and everyday life sooner than anyone expected. The question now is not if this will have an impact, but how severe it will be. At exactly 10 a.m. Eastern Time on Wednesday, January 21st, 2026, the marble halls of the United States Supreme Court became the epicenter of what economists are calling the most consequential threat to American monetary independence in over a century. As 9 justices settled into their seats, the world's financial markets, global economists, and millions of Americans anxiously awaited a decision that could fundamentally alter the relationship between presidential power and the institution that controls the world's most powerful economy. Reuters. In the courtroom's public gallery, 2 figures sat with particular intensity. Lisa D. Cook, the embattled Federal Reserve governor whose job hangs in the balance, chatted animatedly with supporters before falling silent as arguments began. Across the room, in a far corner, a seating choice laden with symbolism, sat Jerome H. Powell, the Federal Reserve chairman himself, under criminal investigation by President Trump's Justice Department. The presence of both officials underscored the existential stakes. This wasn't just about one governor's employment. This was about whether the Federal Reserve, created in 1913 to shield monetary policy from political whims, would survive as an independent institution. The New York Times. After nearly 2 hours of intense questioning, the Supreme Court appeared deeply reluctant to hand President Donald Trump the sweeping power he seeks, the authority to fire Federal Reserve officials at will. But the justices' skepticism doesn't mean Cook is safe or that the Fed's independence is secure. The chain of events that brought this case to America's highest court began not with grand constitutional questions, but with paperwork from a Georgia apartment. In August 2025, Bill Polt, Trump's hand-picked director of the Federal Housing Finance Agency, made a stunning public accusation. Lisa Cook, a Federal Reserve governor appointed by President Biden in 2022 as the first Black woman to hold the position, had committed mortgage fraud. NPR. The allegations centered on mortgage documents Cook signed in 2021 before joining the Fed. Polt claimed Cook had improperly designated 2 different properties, one in Ann Arbor, Michigan, and another in Atlanta, as primary residences to secure more favorable interest rates. Banks typically offer lower rates for primary residences, assuming borrowers prioritize paying mortgages on their main homes. Within 30 minutes of Polt's social media post, President Trump demanded Cook's resignation. 5 days later, he announced he was firing her for cause, posting a termination letter on social media that accused her of deceitful and potentially criminal conduct in a financial matter. The president's reasoning was blunt. Americans shouldn't have their interest rates set by someone who allegedly manipulated rates for personal benefit. But Cook's legal team immediately pushed back with documents that told a different story. They acknowledged an inadvertent notation on one mortgage application, but provided evidence that Cook had properly disclosed the Atlanta property as a vacation home in other documents submitted to the lender. No charges have been filed, no investigation completed, no hearing held. Reuters' Cook's attorneys made an explosive accusation of their own. The mortgage fraud allegations were a pretext, a legal smokescreen for the real reason Trump wanted her gone. That reason, they argued, was Cook's resistance to the president's relentless demands for dramatically lower interest rates. Trump had made no secret of his frustration with the Fed's monetary policy, repeatedly calling for rates to drop to 1%, and boasting that he would soon have a majority of loyalists on the 7-member Fed board, weaken, if not shatter. The court's unprecedented warning. As D. John Sauer, the U.S. Solicitor General, rose to defend the president's action, he faced a judicial panel that seemed unified in its concern, a rare sight in today's deeply divided Supreme Court. Conservative and liberal justices alike pressed Sauer with pointed questions that revealed deep skepticism about the administration's legal theory. Justice Brett Kavanaugh, a Trump appointee and typically sympathetic to executive power, delivered what may have been the hearing's most damaging assessment of the government's position. Your position that there's no judicial review, no process required, no remedy available, very low bar for cause that the president alone determines. I mean, that would weaken, if not shatter, the independence of the Federal Reserve, Kavanaugh told Sauer. Reuters. The phrase weaken, if not shatter, resonated through the courtroom. Here was a conservative justice, appointed by Trump himself, suggesting that the president's own legal theory could destroy one of America's foundational economic institutions. Justice Amy Coney Barrett, another Trump appointee, questioned why the administration had denied Cook any hearing to defend herself. It would not have been that big of a deal for Trump to sit down with Cook and lay out the alleged evidence against her, Barrett observed. She then asked a question that went to the heart of the case's real-world implications. We have amicus briefs from economists who tell us that if Governor Cook is fired, that would trigger a recession. How should we think about the public interest in a case like this? If there is a risk, doesn't that counsel caution on our part? Reuters. Chief Justice John Roberts appeared troubled by the administration's claim that once a president asserts cause for firing a Fed official, courts cannot review that decision. Roberts asked Sauer to explain whether his argument would hold even if the mortgage allegations stemmed from an inadvertent mistake contradicted by other documents in the record. When Sauer insisted it remained quite a big mistake, Roberts responded skeptically, "We can debate that." Even the court's most conservative members expressed reservations. Justice Samuel Alito noted that the administration had handled the case in a very cursory manner, pointing out that no court has ever explored those facts. Are the mortgage applications even in the record in this case? Justice Clarence Thomas questioned whether the Fed should even be considered an executive branch agency subject to presidential removal authority, noting an academic dispute about whether or not the Federal Reserve's open market operations constitute executive power or something else. To understand what's truly at stake in Trump versus Cook, one must understand a dark chapter in American economic history and why Congress deliberately designed the Federal Reserve to resist presidential pressure. The year is 1970. President Richard Nixon, facing re-election in 1972, wants lower interest rates to stimulate the economy and boost his electoral prospects. He installs Arthur Burns, his former economic advisor, as Federal Reserve Chairman. Burns, whether from genuine economic judgment or political pressure, obliges. The Fed keeps rates low, despite warning signs of gathering inflation. The New York Times. The consequences were catastrophic. By the mid-1970s, inflation soared above 10%, then above 13%. Americans watched their savings evaporate. The cost of groceries, gas, and housing skyrocketed. The economy experienced stagflation, the nightmarish combination of high inflation and high unemployment that economic theory said was impossible. The dollar's value plummeted internationally. It took Paul Volcker, who became Fed chair in 1979, to break inflation's back, but only by raising interest rates so dramatically that he deliberately triggered a painful recession. Unemployment hit double digits. Businesses failed. Families lost homes. But Volcker held firm, understanding that short-term political pain was necessary for long-term economic stability. By 1982, inflation fell from over 13% to around 3.8%. The American economy, though battered, was saved. If Volcker hadn't succeeded in making price stability the fundamental prerequisite for the operation of the free market economy, we would have lost that economy and our productivity, said Robert L. Hetzel, who worked as an economist at the Richmond Fed from 1975 to 2018. Hetzel issued a stark warning about the current case. If they decide against Cook, then this process of taking over the Fed is greatly accelerated, and we just jumped back into the 1970s. The New York Times. This history explains why Congress, when it created the Federal Reserve in 1913, built multiple guardrails to protect monetary policy from political interference. Fed governors receive 14-year terms, longer than any president can serve, with staggered appointments ensuring no single president can remake the entire board. Governors can only be removed for cause, a term deliberately vague but universally understood to require serious misconduct in office. The Fed controls its own budget and staff, free from congressional appropriations pressure. These protections rest on a simple recognition. The policies necessary for economic health are often politically unpopular in the short term. No president wants to raise interest rates before an election, even when inflation demands it. No politician wants to cool down an overheating economy, even when a crash looms. The Fed's job is to make the necessary but unpopular decisions, which requires independence from those facing voters. You're fired. The process problem. Beyond the substantive question of whether Trump has cause to fire Cook lies an equally troubling procedural issue: the manner of her termination. No hearing, no opportunity to present evidence, no chance to confront her accusers. Just a social media post, 30 minutes after the allegations surfaced, demanding her resignation, followed 5 days later by another post announcing her firing. Paul Clement, the veteran Supreme Court litigator representing Cook, argued this process violated both the Federal Reserve Act and Cook's constitutional right to due process under the Fifth Amendment. At no point did he invite a response to the allegations. To the contrary, his public comments made clear that he was not interested in hearing Governor Cook's response and that she should either resign or be fired, Clement told the justices. The New York Times. Justice Neil Gorsuch, probing what adequate process might look like, posed a hypothetical to Sauer, calling Ms. Cook into the Roosevelt Room, sitting across a conference table, listening for, I don't know how long, how much evidence, is a lawyer required, and then making a decision. Could that suffice? Just a meeting across a conference table finished with, "You're fired"? The Trump administration's position is that the president gave sufficient process by publicly announcing the allegations and waiting 5 days before firing Cook. During that time, they argued, she could have responded publicly. Sauer insisted that requiring a formal hearing would create needless delay and raise further constitutional concerns about courts interfering with presidential prerogatives. But Justice Ketanji Brown Jackson pressed Sauer to reconcile two seemingly conflicting positions: his claim the president has broad discretion to remove a Fed governor and his recognition that Congress included tenure protections for Fed governors to shield the Fed's independence from White House interference. How does that further the aims of the statute? Jackson asked. Reuters. The question cut to the heart of the matter: if for cause, protections mean so little that a president can fire a Fed governor based on unproven allegations about conduct before taking office without any hearing or judicial review, what protection exists at all? The Powell factor, a crisis within a crisis. Even as the justices debated Cook's fate, a parallel drama deepened the case's significance. Less than 2 weeks before the oral arguments, the Justice Department served Federal Reserve Chairman Jerome Powell with grand jury subpoenas threatening criminal indictment. The alleged crime, supposedly lying to Congress about cost overruns on renovations to the Fed's headquarters building in Washington. Powell, in an extraordinary and unprecedented public statement, denounced the investigation as political retaliation. Research and experience show that Federal Reserve independence is essential to fulfilling the congressional mandate of price stability and maximum employment, Powell declared. That is why Congress chose to insulate the Federal Reserve from political threats while holding it accountable for delivering on that mandate. Reuters. The message was unmistakable. Powell believed the Trump administration was using criminal investigations and threats to coerce monetary policy changes. Trump himself had repeatedly attacked Powell for refusing to cut rates more aggressively, at one point declaring on social media, "Anybody that disagrees with me will never be the Fed chairman." Powell's term as Fed chairman expires in May 2026, though he could remain as a governor through 2028. The criminal investigation complicates Trump's plans to nominate a replacement who shares his vision of dramatically lower interest rates, potentially as low as 1%. Several Republican lawmakers, Wall Street executives, and even some Trump allies have criticized the investigation as undermining the Fed's credibility domestically and internationally. The timing is not coincidental. As the Supreme Court considers whether Trump can fire one Fed official, the administration simultaneously threatens criminal prosecution of another. The twin pressures reveal a comprehensive campaign to assert presidential control over monetary policy, precisely what the Federal Reserve's structure was designed to prevent. What for cause actually means, At the technical heart of the case lies a deceptively simple two-word phrase, for cause. The Federal Reserve Act says governors can be removed for cause, but never defines the term. In 113 years, no president has attempted to fire a Fed governor, leaving this question unanswered until now. The Trump administration argues for cause gives the president broad latitude to fire officials for misconduct, incompetence, failure to perform statutory duties, and any other faults implying an unfitness for the place. Under this reading, alleged mortgage irregularities from before Cook took office would qualify, especially given her regulatory role overseeing financial institutions. Cook's team counters that for cause incorporates decades of legal precedent and common law understanding. They point to similar removal statutes for other agencies that specify inefficiency, neglect of duty, or malfeasance in office. Language from the Federal Trade Commission's founding statute that Congress was aware of when it reenacted the Fed's for cause provision in 1935. Under this reading, cause requires serious misconduct connected to official duties, not private conduct predating government service. The Chamber of Commerce, in an influential friend of the court brief, warned that the administration's position would transform tenure protections for Fed governors into at-will employment. The brief argued, that makes no sense. There's no rational reason to go through all the trouble of creating this unique quasi-private entity that is exempt from everything from the appropriations process to the civil service laws, just to give it a removal restriction that is as toothless as the president imagines. SCOTUS blog. The path forward, what happens next? After 2 hours of arguments, an emerging consensus appeared among the justices. This case needs to return to lower courts for a fuller exploration of the facts. But that procedural conclusion leaves unresolved the critical question of whether Cook keeps her job in the meantime. The Supreme Court's temporary order last October allowed Cook to remain as a Fed governor while the litigation proceeds, an order that remains in effect. Based on Wednesday's oral arguments, a majority seems inclined to maintain that status quo, keeping Cook in her position pending further proceedings. A ruling is expected by the end of June 2026, though it may not be the final word. The justices could affirm the preliminary injunction keeping Cook in place while lower courts develop a fuller factual record about the mortgage allegations, provide guidance on what for cause means under the Federal Reserve Act without definitively resolving Cook's specific case rule on procedural requirements for how a president must proceed when seeking to remove a Fed governor, address judicial review of presidential removal decisions. Can courts second-guess a president's assertion of cause? What seems least likely, based on Wednesday's arguments, is an immediate green light for Trump to fire Cook. Even the court's most conservative members expressed concern about the thin factual record, the lack of process afforded Cook, and the implications for Fed independence, the stakes for millions of Americans. For most Americans following this case from afar, the legal technicalities may seem arcane, but the real-world implications touch every household in the country. The Federal Reserve sets interest rates that determine mortgage costs, car loan payments, credit card rates, and savings account returns. Those rates affect whether businesses hire or fire, whether families can afford homes, whether retirement savings grow or stagnate. Getting monetary policy right means the difference between prosperity and recession, between stable prices and devastating inflation. If the president can stack the Fed board with political loyalists who prioritize his electoral prospects over economic fundamentals, the consequences could echo for decades. Economists submitted numerous friend-of-the-court briefs warning that allowing Cook's removal could trigger market instability and potentially recession. International central banks would lose confidence in the Fed's independence. The dollar's status as the world's reserve currency could erode. Inflation expectations, a critical factor in actual inflation, could become unanchored from reality and tied instead to political cycles. Trump's stated goal of interest rates as low as 1% might sound appealing to borrowers, but rates that low in today's economy could fuel dangerous asset bubbles, reignite inflation, and set the stage for a devastating financial crisis. The 2008 housing crash began, in part, because artificially low rates encouraged unsustainable borrowing, a turning point for presidential power. Trump versus Cook represents more than a dispute about one official's employment. It's the latest battle in a broader war over the scope of presidential authority, a war in which the Supreme Court's conservative majority has generally sided with expansive executive power. In prior cases, the court has allowed Trump to remove leaders of independent agencies, chipping away at decades of precedent protecting those officials from political interference. But last year, in a cryptic passage of one opinion, the justices signaled the Fed might be different, describing it as a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. That language and Wednesday's skeptical questioning suggests the court may draw a line at the Federal Reserve. The justices seem to recognize that some institutions require protection from political control, even at the cost of limiting presidential power. The Fed's role in global finance, its historical independence, and the catastrophic consequences of political interference in the 1970s may provide compelling reasons for the court to preserve limits on executive authority in this specific context. As the Supreme Court session adjourned Wednesday afternoon, Lisa Cook left the building to an uncertain future. She remains a Federal Reserve governor for now. The investigation of Chairman Powell continues. Markets await clarity, and millions of Americans whose economic futures depend on sound monetary policy watch nervously as the battle for the Fed's independence unfolds. The question that began this evening's report remains unanswered, not if this will have an impact, but how severe it will be. If the Supreme Court allows presidential control over Fed appointments and removals, the damage could reshape American economic life for generations. If the court draws a line protecting Fed independence, it may preserve one of the few remaining checks on political power in an age of expanding presidential authority. One thing is certain: the decisions made in the coming months in a marble courthouse in Washington will determine whether the institution that safeguards American prosperity remains independent or becomes just another political prize.